Okay, so hello everyone. I am Lokesh Pulchandani, the India Initiative Lead at GW Competition and Innovation Lab. And today I welcome you all for the inaugural session of India Initiative on by the competition on the competition issues by GW Competition and Innovation Lab. Uh, just to give you some background about the lab is collaborative partnership effort with OECD on various global perspective of competition regime. And today on this inaugural webinar, we will be discussing about the 15 years of India's competition law journey. With me today, we have a panel of 6 people who are also an advisory board for our GW Competition and Innovation Lab. I will introduce one by one to all of them, and then we can go around and talk about the topic. To start with, we have Augustine Peter, sir, who is a former member of Competition Commission of India. Then we have Shilpi, who is professor at Jindal Global Law School. Then we have Mr. Manveer Singh, who is an assistant dean at the Jindal Global Law School. We have Payal Malik, who is a former Competition Commission of India Economic Division head. Then we have Anshuman, who is partner at Khaitan and Co, leading the competition practice there. And we have Divya Swami, who is a partner at DNY Law. With this introduction, now I'll start uh, to discuss about the topic, and I'll first pose and go to Augustine Peter, sir. Sir, since you are perfect and the right person to talk about the historical overview for our audience to let them know about the Indian competition regime, how it started, and where we are today. So it would be great if you can take us through the historical background and overview of the competition regime in India. Over to you, sir.
Thank you very much, Lokesh. I hope I can be heard by everybody. Yes. See, as we all know, India was under colonial rule for around 300 years, 3 centuries around, and the industry was hardly existing when we got independence. And to start with, we had an industrial policy where the concentration was on building commanding heights of the economy in the public sector. And then it was noticed that there was substantial increase in inequality and concentration of wealth. So a committee, Mahalanobis Committee in 1960, highlighted the growing inequalities. It was noticed by the government of the day that the directive principles of state policy of the Constitution of India, Article 39B and C, basically related to prevention of concentration of economic power to the common detriment. So that was this concentration was increasing, so something has to be done. So a monopolies inquiry committee, that is 1964, was instituted, and they came out with a report. So the result was the Monopolies and Restrictive Trade Practice Act of 1969. So broadly, this act had a commission and a director general and the government of India, the ministry. So monopoly was, so they had two aspects. Its mandate was monopolistic trade practice and restrictive trade practices. So it was and monopoly was defined in terms of assets, 200 millions of assets of an enterprise alone, or along with this interconnected undertakings. We don't have time to go into the interconnection aspect. So then, and also monopolistic trade practices. So such enterprises were defined as MRTP or monopoly enterprises, and they had to register themselves with the government, and their expansion, diversification, appointment of directors, everything was regulated, controlled by the government. Again, MRTP, monopolistic trade practices as defined, included basically maintaining prices, unreasonably preventing or lessening competition, protection, limiting technical developments, etc. So basically the issue was that monopolistic practices were regulated by the central government. And the MRTP Commission had maybe some SOMOT or advisory powers only in this regard. Again, in the modern sense of mergers, that again was in the sole domain of the government, central government. MRTP Commission, Monopoly Commission had no role in that, except that if it is referred to them, they can advise on that. So that is, then the second aspect is restrictive trade practices. So this is defined in terms of trade practices that are likely to prevent, distort or restrict competition in any manner. I'm not going into the details. Now the structure of the commission was, there was a commission headed by a retired justice and a director general. And DG had to rely on the commission because commission alone had the power of summons, ensuring attendance, etc. So that was the arrangement which was in place. So there were, as regards restrictive trade practices, there was 12 kinds of practices which were deemed to be restrictive. So it became more easy. It was sort of a per se type of practice. I am not going into the details, but coming to the remedy, because we have to go a long way. MRTP Commission, the Monopoly Commission, can only recommend remedies, and the structural remedies and division of enterprise were basically only to be enforced and by the government. Again, penalties and civil imprisonment were provided in the Act, but however, the commission can only recommend, and it has to be adjudicated by the Sessions Court. So appeals laid to the Supreme Court of India. Now, there was a high-level committee on competition law and policy. I'm just rushing to that. So what has happened is that 1991, there was a large-scale liberalization of the Indian economy. And based on that, it was found that the way MRTP Commission was there, it was not in sync with the liberalized economy. So what had happened was, initially it was 200 million rupees asset limit for being declared as a monopoly company. It was raised to 100 million rupees in 1984, and in 1991 it was done away with. So monopolistic aspect was taken away. Mergers, again, that was taken out of the purview of the competition. So only what had happened is that UTPs, that is unfair trade practices, something was added in 1984, plus restricted trade practices that remained after 1991. Now because there was a decision by the government of India in I think it was in 1999, that there should be a reform of the Act, and a Raghavan committee, a high-level committee, was constituted. And the Raghavan committee, after consultation with the industry, with all the other stakeholders, came to the conclusion that competition was not that important in the Act. The word itself of competition figured only twice in the MRTP Act. Precise definitions were missing. For example, cartel, abuse of dominance, predatory pricing, they were not clearly defined. With the result, there were conflicting decisions at the different levels, even by the Supreme Court. So MRTP Act was not fitting in with the merged and the new regime, and WTO had also the process of building in competition and trade issues into the international multilateral trading system. So keeping all this in view, there was some recommendations came by this committee, very major recommendation. They recommended that they recommended a series of changes in the law. So, and the law that is to make it a broadly in line with the international best practice. So with the result, the competition law was I think that aspect will come. I will only going into what were the defects, issues identified by the commission. So the commission recommended a new competition law because it was not in sync with the and role of industrial organization and economics in competition law was also also emphasized. They recommended a soft regime of voluntary notification regime for mergers, which finally was made mandatory regime after consultation. That was not accepted. Their voluntary notification regime. Inclusion of public sector and government department because MRTP did not cover public sector and government departments. And the recommendation was only sovereign functions of government should be exempted. This recommendation also found place in the later law, which was presumption rule was recommended in very limited areas. Otherwise, predominance must be to the rule of reason. Again, in keeping with the modern competition laws. Courts have, and then the courts had to adjudicate. That also was, is it the time coming up? You have to give me a warning. So courts had to be out and a specialized body has to be constituted. That's why the Competition Commission of India came to the existence. Then competition advocacy. Advocacy was not known to MRTP Act. So that was also brought in. With the result 2003, 14th October, CCI was, the act was in 2002 and 14th October 2003, Competition Commission came into being and the details I am sure that others are going to say. And there was a writ petition stating that it is not inappropriate to have a non-judicial person as a chairperson. So, and then Supreme Court ruled that you come to make a necessary adjustment. So 2007, there was an amendment, major amendment, where the appellate tribunal was constituted, which later became NCLAT. And commission became only an expert body. And there was a DG which is attached to the commission. And so thereafter, what had happened is that the first enforcement of the antitrust provision, that is section 3 and 4, started in 2009, and merger enforcement, that is combination in the language of the Indian Competition Act, competition law, that started in 2011. So I think here I stop because I rushed a bit because the time is very limited. I think 7-8 minutes. Thank you very much.
Thank you so much, sir. I think this was very insightful of how you went through MRTP to Competition Act and what were the issues that were being there during that entire process. So it was very insightful for everyone here. Thank you so much, sir. Now I would like to go to Shilpi, who is a professor at Jindal. And Shilpi, to you, my question is, what, according to you, are some of the more like unique aspect of Indian competition law? Like, it would be great if you can give some comparative analysis with the EU and United States, but what are the unique features that you see in the Competition Act of India?
Thank you so much, Lokesh. And it's wonderful to be part of this opportunity with such eminent experts in the field. And thank you so much, Augustine sir, for that brilliant history of competition law. So I will limit my remarks because of time to sections 3 and 4 of the Competition Act, which are on anti-competitive agreements and abuse of dominance, respectively. But before that, I just wanted to mention one thing that I find particularly interesting about the competition law regime in India, which is not connected to these two sections. So the preamble of the Competition Act in India states that the objective is to promote competition and to prevent adverse effects on competition in India. And with that objective in mind, the way that the law has been structured includes a number of interesting features to achieve those objectives. And one of them is how a case can be brought to the CCI or an information can be brought to the CCI. So of course, CCI can take its own initiative and bring cases suo moto or on reference from the federal government or state governments. But obviously, information can be brought to the CCI to initiate a case, but it doesn't have to be from an aggrieved or an injured party, unlike in other jurisdictions where the party has to have standing to bring a case. In India, anyone can bring a case, which is called an information to the CCI. And we've seen very significant cases like Umar Javed versus Google, which is the Android case, which was brought by a law student and two very junior competition law researchers who were inspired by the EU case to bring this case before the CCI. So that's one interesting feature that has really facilitated the CCI to look at a lot of different kinds of competition law cases and to really bring in the broader objective of promoting more competitive markets in India. So with that, let me move to section 3, which is on anti-competitive agreements. So in India, unlike in other jurisdictions like EU, which has a by object and by effect distinction when with respect to anti-competitive agreements. In India, we treat anti-competitive agreements based, we used to treat them based on horizontal and vertical. And I think they realized that maybe like this distinction between horizontal and vertical wasn't working out so well. So we've had amendments to the Competition Act last year that changed this distinction to horizontal and non-horizontal agreements. So now we treat these agreements differently, horizontal and non-horizontal. But maybe something to think about, that the by object, by effect distinction would have been an interesting one to have. And then we have, as Augustine sir mentioned, per se rule of illegality, but our own version of it for horizontal agreements. So it's a bit different from what is present in other jurisdictions like the US, because defendants, opposite parties against whom a case is brought, do have the opportunity to rebut a presumption of illegality arising from a horizontal agreement. And they will use factors that the CCI generally uses to conduct a rule of reason analysis for vertical agreements to rebut that presumption of illegality for horizontal agreements. So there is an opportunity to carry out a balancing analysis within the framework of the Competition Act, although the CCI has not really used it in that sense. But it is present, and it gives some flexibility to the assessment of horizontal agreements. And then for vertical agreements, we have, again, our own version of a rule of reason analysis, where the CCI is supposed to look at factors set out under section 19, subsection 3 of the Competition Act, which is a set of factors, again, that are inspired by the jurisprudence in the US and EU, but very much sort of something that we have uniquely in India. And we don't have much guidance about how the CCI will analyze or to conduct a rule of reason analysis. And it also hasn't come in from case law, unlike in the US, where there's much more guidance on how a rule of reason analysis should be conducted. Indian jurisprudence hasn't really evolved to that extent to tell how a rule of reason analysis will be conducted. And the other kind of interesting aspect of the anti-competitive agreements provision in the Indian Competition Act is that for horizontal agreements, we have an exhaustive set of agreements that will constitute an anti-competitive horizontal agreement. So you have to bring an agreement within that set of agreements. And for vertical, there is a non-exhaustive set, but the statute also has like definitions of these agreements. So it's much more informative of what kinds of agreements will constitute anti-competitive agreements than what you have in the EU and US. And then moving on to section 4, which is on abuse of dominance. So this is obviously a concept that is very much inspired from EU law. And we have a definition of dominance in our statute, unlike what you have in the US, or even under Article 102 of the TFU does not define dominance, but we have a definition of dominance. That definition is very much taken from EU law. And then again, we have a set of conduct that is an exhaustive set of conduct, which will be considered abusive. So you have to bring an abuse of dominance case within one of those categories of conduct that are listed under section 4 of the Competition Act, unlike other jurisdictions, in particular the EU, where the set of conduct is not an exhaustive set of conducts. And of course, in Section 2, Sherman Act doesn't have any of this kind of detail in it. And then the interesting part of Section 4 is sort of whether we have whether we follow a rule of reason analysis for abuse of dominance cases or not. So the wording of Section 4 is very clear that the CCI is not required to conduct an assessment of anti-competitive effects. You just have to show that a dominant enterprise is engaging in conduct that falls within a category of abuse. But the CCI has in the past conducted some kind of assessment of anti-competitive effects in certain cases and not done so in other cases. And this jurisprudence has now been clarified by the appellate tribunal in the case against Google, which is the Android case, where the appellate tribunal has said that Section 4 requires carrying out an assessment of anti-competitive effects, but has not really gone into much detail about how this kind of assessment will be carried out. And then, of course, they went on to say that the CCI did do a good job of proving anti-competitive effects in this case. So now we seem to be at this very interesting stage in our jurisprudence where the CCI will be required probably to prove anti-competitive effects, or at least do some kind of effects-based assessment in abuse of dominance cases under Section 4 of the Competition Act. So we have to see how that pans out in the coming cases. And the other interesting aspect of abuse of dominance that's different, in particular from US law, but not EU law, is that we do recognize exploitative abuses. So we have conducts that constitute exploitative abuse of dominance within our law, which is not there in US law. So with that, I think my time is also up, and I'm happy to take questions later.
Thank you so much, Shilpi. It was very insightful, like the way how you connected the EU and US comparison in Section 3 and 4, and how Indian competition regime is different in itself on how they are dealing with cases and their jurisprudence, and how things are in terms of approaches in conduct-based or impact-based analysis. Thank you so much. Now I would like to call Anshuman to give us some insight about the merger regime in India. It's very interesting to see that, and that's also a kind of a question to you, Anshuman, that why has the CCI not resorted to block any merger transaction as of now since its inspection? And what do you think in terms of the new the deal value threshold that has been there or been proposed by the government? Does that impact the entire merger regime in India? What do you think about that, Anshuman?
So thanks, Lokesh, for having me here. Interesting question, of course. The point actually is that it's been around 13 years of merger control now in India that we've had. It has been a fairly interesting ride in these years. Unlike enforcement sections, which Shilpi just covered, Section 3 and 4, the merger control regime actually was brought into effect a little later in 2011. So we've had about 13 years now, over 13 years now of a merger control regime in India. The kind of cases and the kind of analysis that the commission itself has done has matured significantly. Fortunately, over the years, the commission itself has upscaled. They have had a lot of best practices which they have been able to adopt from around the world. Bring in experts from around the world. The kind of analysis is done in pretty much in line with how you would see it happen in a lot of other mature jurisdictions as well. And of course, over the years, in the last 13 years, they've had a chance to examine a variety of sectors in terms of the transactions that they've had to review. So effectively, I think the expertise and the skill set has developed phenomenally over the last 13 years, and that is very evident in the kind of analysis we see on cases practically on a day-to-day basis. Why have we not really seen a transaction being blocked, perhaps, was the first question. Practically, I think the point here is that it's the CCI itself does not want to be seen as a regulator which is anti-investment. It does not want to see to be a regulator which is anti M&A as well. It is pretty evident from the fact that they are trying to see what kind of resolutions can be brought about apart from blockage. And blockage, of course, while the powers definitely are there, until now that the cases they have seen, it appears that they have believed that it's best to have had some remedies, either divestments, structural remedies, or even behavioral remedies, which require a fair bit of innovation in themselves. And those seem to have had enough of an effect for the CCI to believe that the transaction would not end up causing any appreciable adverse effect on competition, which is a standard for assessment. So effectively, it's a twofold thing. One is that they believe that the remedies available would be sufficient, number one, and number two, obviously, if there is a blockage of a transaction, it could have the unintended effect of sort of resulting in a situation where investments into the country fall, which is of course not the idea for any competition regulator and not the kind of outcome that any emerging economy would really like for itself. So on that's my take on it. On terms of the deal value threshold, it's something which is very new. It's actually been enforced 10 days back on the 10th of September. So it's extremely new. We've of course had a lot of queries in the last few days since the time this has come up, and it's still something that we are trying to understand fully. Would it have an impact on how deal making happens and how perhaps transactional work really would get impacted? We of course do believe that there would be an uptick in terms of how transactions would be examined. We of course do believe that a lot of transactions would get impacted because of this going forward, considering the fact that this now takes into account another set of thresholds altogether, which were not examined until now. So while of course the initial intent of this particular threshold was to track and target tech transactions and M&A transactions in the tech space, but that's not what the ultimate law really looks like. It's obviously sector agnostic, so it captures transactions in all spaces. We do expect to see at least a 10-12% uptick in terms of number of transactions which have been which will be notified going forward. But I think it's something that only time will tell as to how effective it is. I think effectiveness of the deal value thresholds is still under consideration practically around the world. Countries like Austria and Germany have had it for a bit, but they've had mixed results. So hopefully we'll be able to track it here in India in a very different economic context to see how it really works out.
Thank you so much, Anshuman, in taking us through the intricacies of the merger regime in India. It was very insightful, and it was very crisp and good to know about what's happening and what's going to happen in the coming future with the new deal value threshold thing that's there in India. So now I would like to pass on to Payal Malik, ma'am. Payal Malik, ma'am, with you being into CCI, working on an economic division from a very long time, and now you have a better understanding of the competition regime in India. So to you, my question is on how does economics, and more specifically in terms of the market studies that CCI is doing these days on a regular basis, what do you think on the market studies and the emerging issues that CCI is dealing with on these kind of toolkits as an advocacy under the competition regime in India?
Yeah, thank you. Thank you, Lokesh. And it's wonderful to be here and talking about something which is very close to my heart. So I will divide my comments basically into two. When I joined the commission as an economist with no law background, I wanted to understand why am I there, and I had some certain existential issues to begin with. But then I read a piece in a newspaper that antitrust law is the glamour street for economists, and the reason being that it is around the discipline of economics, because the competition law, the Indian competition law, like any other modern competition law, has economic goals. Should be mentioned about the preamble. And the preamble, and this, we used to have these discussions at the commission, it basically has the words keeping in view the level of economic development in India. So this law is, and then it goes on. So the economic goals which are embedded in this law was to promote, so go beyond just size, go beyond structure, but look at behavior and conduct, and to look at the behavior and conduct on the touchstone of economic efficiency and consumer welfare. So therefore, the law is intrinsically linked with the discipline of economics, and economic principles, because we have been debating whether or not AOD, that is the abuse of dominance section, is an effects-based section or is just pure per se. But the economic principles, even in the abuse of dominance section, are embedded in the law itself. So in some sense, though an effect analysis is not done, but the architecture of the law is such that adjudication does entail. So whether or not that conduct has actually taken place, so adjudication does entail the appreciation of the economics of markets and business conduct from a lens of economic efficiency and consumer welfare, be it in terms of defining relevant markets, assessing the market structure, the nature of the competition, the entry conditions, or identifying the theories of harm, or in the assessment of efficiencies. And as the law was developing, though we were late, so to speak, but given the history, when the law picked up post 2009, India leapfrogged a lot because there were huge advances in economic thinking that informed the evolution of legal doctrines in antitrust. And as the antitrust landscape progressively shifted from just per se rules or anti-competitive by object, the bright line prohibitions, not through a per se rule, but through a rule of reason framework, meant that economics and economic discipline had to be integrated in the adjudication of law. Today, as an important part of the evidence which is presented to the commission in most of the cases is economic in nature, and the role of economics and economists in this branch of law is well recognized across jurisdictions, with incorporating economic reasoning into case analysis and an increasingly growing judicial reliance on economic evidence. We saw that in the NCLAT appeal, in the Google Android order. A heavy dose of economics is present in the NCLAT order, and it was because of the submissions and because of the arguments and hearings which involved a lot of economic debates. And economics in antitrust is not just quantitative tests or tools, because initially when again I faced that dilemma, because economists were thought to be people who do this number crunching, will come out with some kind of a number, say it's competitive or anti-competitive. That's not how economics is integrated into competition law, because a deeper understanding of the discipline of economics will allow for an understanding of the nuances of the markets. So how is the market organized? What is the structure of the market? Is the structure in itself a reason to be alarmed? Or there are other factors such as contestability, entry in the future, rapidly changing market technologies, and other market realities which need to be integrated in the assessment of a particular conduct. The economic impact of enforcement activities of the competition authority also needs to be evaluated, and the economics team provides guidance and on methodological issues of economics in the application of competition rules. So when I say competition rules, if you look at the 10 commandments which have come out, say, in a Google order, in the Competition Commission of India's final order in October of 2022, those competition rules which have been proclaimed as remedies, so to speak, are a consequence of very deep understanding of digital markets, of the conduct in question, and thus then helps in developing general rules for a particular case, which can be then transformed to other cases with similar kind of behavior or conduct. It is not surprising that 45 of the 67 jurisdictions in a recent GCR, that is a Global Competition Review Survey, had a position of a chief economist in the competition authority. To bring back the Indian context, before I move to your second question on market studies, because market studies is a very, very important now part of the antitrust as well as a merger assessment toolkit in order to understand markets before adjudication or to guide or influence adjudication. A recent High Court judgment had clarified the multifarious roles that the Commission has in addition to enforcement and adjudication functions, and it accorded the Commission the role of an expert body. So just to quote, the judgment said, the creation of CCI and investing it with multifarious functions which extend to directing and overseeing investigations, fact gathering, advising the government on policy as an expert body, and advocating competition. So advocacy is the heart of, or one very important limb or pillar of the Indian competition law, which requires, again, the understanding of the economics of the market in order to inform policy. So and this is in addition to just issuing directions or orders against specific entities or companies with aim of eliminating a practice found pernicious or one which constitutes a barrier to competition and fair market practices. So this was by and large the milieu in which, and the fact that India is now on a major economic power, and being a major economic power, we need competition and competitive markets, and competitive markets running on the principles of the frameworks which economists have now made the lawyers and the legal fraternity understand, because they have been able to guide the legal doctrines also. So it is not just limited to, as I said, some kind of number crunching, but it is important that clarity on market conditions and counterfactuals are critical for choosing enforcement priorities and remedies for optimal deterrence of anti-competitive conduct, because side by side you have to preserve incentives for innovation, which is becoming a key detriment for overall economic progress. And therefore, advances in economic thinking have informed the evolution of legal doctrines in antitrust. One recent example is how do competition authority adjudicate matters in digital markets. The economic theory of multi-sided markets has, in fact, changed certain accepted hypotheses and certain accepted goals of competition law, which was pursuance of consumer welfare. The definition of consumer was expanded in these theories of multi-sided markets built by economists. The intermediation activities of these digital markets or platforms meant that consumers were no longer just the end consumers. The conduct of this intermediary platforms and digital markets qua the business users was also an important prism through which conduct needs to be looked at. So by and large, I think there are few areas of laws which draw more heavily or more directly on economics learning than competition or antitrust law, because the reason is fairly simple, and it is with the help of economics that you will condemn practices, because it is a behavioral law, no longer a structural law where a number that is 80% market share or 60% market share is non-kosher, and the law applies through rules. Is that markets need to be understood, and competition law needs a screening device, and that screening device happens to be economics. Coming back to your question of market studies, increasingly world over, there is a technocratic shift in antitrust authorities' approach to enforcement, because if you have to free it from ideology and it has to be based on well-grounded research, then in order to make antitrust an expertised, administrative and enterprise focused on managing market structures and industrial practices, a problem-solving approach is required. And so that requires an understanding of the details of the market. So just highlight some important emerging issues which were taken up in the market studies at the Commission. A slew of market studies have been implemented. Recently, the Commission has implemented a study on AI and competition. So emerging markets always pose challenges for adjudicators. So for instance, way back in 2019, the market study on e-commerce in India was conducted to develop better understanding of the novel competition issues that were emerging with the growing importance of the digital platform-centric commerce. Some market studies were initiated to sectors where there was observable demand-side issues, which did not allow consumers to make effective choice. Example is pharmaceuticals, because in the pharmaceutical sectors, it was the information, its asymmetry, which meant the consumer choice is not a choice which is based on perfect information, and the role of trade associations in drug distributions and the proliferation of branded generics and entry issues of bioequivalence were taken up in that study. One more important study, I think, which the Commission undertook, and it was an internal study, which guides adjudication in the M&A space. The private equity investments have surpassed or had surpassed strategic investments in India during the pandemic. So therefore, the Commission undertook an internal study to understand common ownership by PE investors. It sought to gauge the underlying incentives of the common investors and to understand the nature of investor rights and whether some of these rights can influence the firm's decision-making with consequences for competition. Various other studies, the telecom market studies, looked at the convergence between the infrastructure layer and the interconnect companies, brought out privacy policies under the lens of antitrust, followed by a suo motu case by the Commission in opening up a case against the WhatsApp's privacy policy. Surge pricing in app-based cab market was another study which was taken up. And so most of these studies do inform the Commission and do inform Commission's adjudication path, whether or not to take up a case and how to look at a case given the understandings which are coming out from those market studies. So I will stop here, and I think going forward, market studies continue to play a very important role in Commission's antitrust toolkit.
Thank you so much, Payal Malik ma'am, and taking us through the economic and the advocacy part of the Commission with more insight on the market studies, which is a new tool for the commission. So it is really exciting to know that how things are going in India with respect to the new trending technology-driven markets. Now, with this, I like to now call Manveer Singh, Dr. Manveer Singh, who is an associate dean at Jindal Global Law School. Uh, my question to you, sir, is with respect to the interface between competition and intellectual property rights. Since you have been working on this area from a long time, it would be great if you can tell us how important is the role of CCI in SEP and frank terms dispute cases, and how the things are in comparison to US and Europe.
Thank you, Lokesh. It's an absolute privilege to be a part of this esteemed company of distinguished panelists. Well, I mean, to be honest, it all took an interesting turn about a decade back when, for the first time, Ericsson, as a prominent patent holder, or let me say specifically an SEP holder, went after several Indian companies and kind of a couple of Chinese companies included in that category, in terms of their not taking a license on what we popularly know as FRAN terms, that is fair, reasonable, and non-discriminatory terms, or they are not being willing to take a license on FRAN terms, and thereby, of course, pretty much being on the cusp of indulging in what we also know as patent hold out. Now, in that regard, what was observed was that all these cases that were filed against these implementers were filed before the Delhi High Court, and some of these Indian implementers, as a form of retaliation or in terms of putting out their side to this entire story, end up approaching the Competition Commission of India vis-a-vis abuse of dominance claims against Ericsson. And again, quite interestingly, all the patents that were involved as a part of these disputes were pretty much the same set of patents that Ericsson had. And all these implementers were alleged to have not been willing enough to take licenses from Ericsson on FRAN terms to these technologies, which were supposed to become a part of the 2G, 3G, and subsequently the 4G standard. The CCI, of course, in the aftermath of its preliminary investigations, came to conclusions which were in stark contrast to what the Delhi High Court actually said at that point, and that kind of opened the debate wide open in terms of how to reconcile the two conflicting judgments, or let's say the two conflicting outlooks that the Competition Commission of India and the Delhi High Court had. Because if, for instance, something like signing an NDA, a non-disclosure agreement, was considered to be justified by the Delhi High Court in cases involving SEP licensing, the CCI considered these non-disclosure agreements prima facie basis to be anti-competitive. Moving on to the more controversial aspect of the royalty base in SEP licensing, which is either the entire market value rule, EMVR, or the smallest saleable patent practicing unit, which is SSPPU. There again, the Delhi High Court pretty much was convinced by the fact that charging a rate as per the entire market value of the end user device was again in line with the FRAND obligations of someone like Ericsson. The CCI basically in almost each of those cases felt the opposite, and their understanding or their observation was that SSPPU was probably the more appropriate way of assessing what the FRAND royalty rate would be. And coming to again the rather the globally controversial aspect of whether injunctive relief should be available to SEP holders, especially when they are under a FRAND undertaking or a FRAND commitment. There again, the CCI considered seeking injunctive relief to be anti-competitive. However, the Delhi High Court felt otherwise, and their opinion was that it would be in line with the three-step test as far as India is concerned if injunctions were granted in such cases because the SEP holders stood to suffer from irreparable loss uh, amongst other things or amongst other conditions. Now, it 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 was pretty much a decade back that all of this happened. But as I see things today, as someone who considers himself, very humbly and in a very modest way, a student of intellectual property law, but deeply interested in SEP licensing, what I now see is some sort of closure likely to arrive sometime soon because the Delhi High Court actually again in about 2015 in around 2015 had upheld the jurisdiction of CCI in terms of their assessing abuse of dominance allegations against patent holders or let's say SEP holders in reference to Section 3, Section 4. But on appeal, it was overturned by a division bench of the Delhi High Court. Now, this matter is likely to be decided, as a final and binding decision by the Supreme Court. Now, as things stand, there seems to be obviously a conflict between how or an alleged conflict between how the Patents Act, which is a special act by virtue of its nature, and the Competition Act, the differences between the two, or whether there is supposed to be any overlapping jurisdiction. As things stand, per the latest decision, the controller of patents the Controller General would basically have discretion over disputes involving any kind of abuse of dominance on the part of patent holders or patentees for that matter. And CCI's jurisdiction for now is out, but there is still a possibility that the Supreme Court might actually uphold either they will uphold the same thing or they might overturn the decision saying that the CCI would probably have jurisdiction just like any other matter, despite the fact that there's quite a debate as to what exactly was the objective of the Competition Act. Was it to basically look into the conduct of patent holders, or was it, of course, Shilpi also, I think, originally mentioned that what was the actual objective, what is in the preamble, and was it supposed to be for the protection of competition in the market? So does that by necessary extension allow you to look into the conduct of patent holders as well? Now, these are interesting times because if we compare the position of CCI as the premier competition authority in India to what is happening in the EU or the US, what is actually quite noteworthy is the recently introduced and rather controversial draft SEP regulation by the European Commission in the European Union. There's been a lot of debate again about that, and most of the stakeholders have actually gone on to hold or hold the opinion, or rather, pretty much firmly emphasize on the fact that the regulation, which is on its well and truly on its path to becoming a law, is kind of lopsided and skewed in favor of the implementers, and is likely to I wouldn't use the word endanger, but definitely likely to be detrimental to the interests of European SEP holders and European innovation. Now, it becomes extremely important because India, traditionally speaking, has always, whether you talk about IP law or whether we talk about competition law, if we talk about IP, well, primarily we've been following the UK model. And our laws are also pretty much aligned with the British laws as opposed to the US laws. If we talk about competition, we're pretty much aligned with the European Commission as opposed to the DOJ Antitrust Division or the Federal Trade Commission in the US, which therefore would also imply that, and it's pretty much a given that India has been keeping a close tab on what has been happening in the European Union, because I very well am aware of the fact that the government is considering a similar action on the lines of what has been proposed in the European Union. However, the role of a competition authority suddenly comes into the limelight because whether it is their mandate to come out with such a legislation or it is not, it definitely is worthwhile if a competition authority actually issues some sort of guidelines in that regard, considering how important SEP licensing is in today's date, and with the impending, outreach of the IoT ecosystem now, it becomes even more important because SEP licensing is not limited to the telecom sector. We've already seen the effect of SEP licensing in the auto sector, and slowly it is having an overarching sort of an effect on other allied sectors as well, which therefore raises the question as to what kind of role should a competition authority really be playing, and whether the CCI in any case should really be looking to put out a set of guidelines for ACP licensing in India, because there was a discussion paper put out by the erstwhile DIPP, which is now the DPIIT in India, in 2017, or rather 2016, and that was followed by a commission, a European Commission communication in 2017. Yeah, so the DPIIT document was a 2016 white paper or discussion paper rather, and the 2017 communication that came from the European Commission, they were pretty much in close proximity to each other. But what we have seen again is stark contrast to what happens in the aftermath of these documents in two different jurisdictions. In the European Union, we've seen now a culmination of all the discussions that went on from 2017 through to 2020, 2021, and last year, when suddenly this draft regulation coming up, and it's only a matter of time when the final voting happens at the European Parliament, because pretty much it has passed two stages and it's just the final stage pending. Yes, Thierry Breton recently stepped down, and he was the brainchild pretty much behind this so-called draft regulation. But when somebody at the helm of a competition authority actually steps down, it does make a difference. If somebody, if whoever succeeds you, whether the person shares the same outlook towards what is happening in that particular domain or not, and what eventually comes of it. But yes, these are interesting times in Europe, definitely. And lastly, if I look at the US situation, US has had again, quite an up and down sort of a thing in terms of the role of the competition authorities, because we all know that antitrust in the US is kind of linked to the Federal Trade Commission and the Department of Justice Antitrust Division, and definitely the Department of Justice Antitrust Division has had a major role to play in policy making as well, because there have been joint policy statements put out starting 2013, and then 2019, and then 2021, or rather late 2020, and then 2021. But right now they've gone neutral. The Biden administration is pretty much neutral on what they would want as the competition policy, or the intersection of IP and competition in terms of SEP licensing. So they've basically left it to the market. That's one way of dealing with things, actually. Rather being proactive, you might as well leave it to the market, or you probably follow a model which has been followed in Japan, which is to put out a guide, not a binding set of guidelines. Well, China has done kind of pretty much the opposite. China has put out a set of binding guidelines, but those have come from some of the courts in China, whether it is the Beijing High People's Court or the Guangdong High People's Court. But definitely, I see a lot of opportunity, or kind of a great window of opportunity for the Competition Commission to maybe have a constructive dialogue, at a larger level, with inviting the stakeholders, and see what is the best way to move forward in terms of the intersection of IP and competition, especially in terms of SEP licensing, because we could pretty much start with a clean slate. Given our situation is very much different to what is the situation in the US and the EU, those are developed jurisdictions. India is not, and countries like Japan and China have really shown the path in terms of how India could possibly look at this. So I would say this is pretty much a real test of character as far as the Competition Commission of India is concerned, or probably this constructive dialogue involving all the stakeholders is concerned. So I'll end with that. Thank you.
Thank you so much, Dr. Manveer. It was really interesting to know what discussions are going on in India in terms of the competition and intellectual property regime and its interface. And thanks for also taking us through the comparative analysis how US, EU, China, Japan are doing in terms of that. Thank you so much. Now, I would like to move to our last but not the least speaker, Divya Swami. Dr. Divya Swami is a partner at DNY Chambers. And I know that, Divya, you have been working on your thesis. You have done your thesis on a very penalty regime of competition law in India. So it would be great if you can tell us what are the factors that has been commonly considered by the Competition Commission of India while imposing penalties on the countervailing parties.
Thank you, Lokesh. Thank you so much for the question. And I'm also very grateful for to you and to the team for having me here, because it's an absolute honor to be speaking among such stalwarts of their field. So thank you so much for this opportunity to be able to express my views on what I think is going on in the penalty regime in India. So, I mean, having said that, of course, it is a very interesting time for all competition lawyers, practitioners, and academicians alike, because there is so much development happening in terms of jurisprudential value in the competition regime. But specifically in the penalty imposition regime, it's undergoing a sizable change. And that is specifically because recently, only in March 2024, we have a set of guidelines, which are the monetary penalty guidelines, which have been introduced. They are a set of recommendations for the CCI as to how imposition of penalties can be done in the cases of contravention of competition law. But before I go into the details of how this is interacting with the field and how the industry is taking it, and also on what are the factors that are specifically being considered, it's also important to understand that fundamentally the penalty regime is covered under Section 27 of the Competition Act, which imposes penalty of up to 10% for contraventions of Section 3 and 4, which have already been discussed by the earlier speakers. Now, notably, this is also at par, and this is in consonance with how the international regime is working. So across the globe, this is approximately the same statutory provisions that apply, because they're all similar in that manner. But I think that the major difference that occurs is in terms of the implementation. That is, how exactly are the commissions implementing this? Because 0 to 10% of the turnover is actually a very, very big margin if we look at it. So if you ask the industry, sometimes the turnovers run into crores of rupees, if I speak specifically about India. And for the larger part of the CCI's, the operation of CCI, we have not had any penalty guidelines, which essentially means that there was a lot of discretion that was available to the members of the CCI. Keeping that in view, there was a lot of institutional memory loss also, because when one set of members are operating, they operate with a different set of precedents that are there, a different set of understanding, different economic principles, keeping in view the economic development in the country. So there have been a lot of variations in the way the CCI has actually implemented or enforced the penalty imposition provisions. However, there are some basic tenets that have been followed in the past as well. It would be completely incorrect to say that there are absolutely no benchmark or no parameters that are being followed, because and if we look at how internationally it has been operating, we also have a set of aggravating and mitigating circumstances. Generally, all of the judgments, and especially in the last 5 to 7 years, all of them have been talking about the aggravating and the mitigating circumstances while imposing penalty on the contravening enterprise. However, again, there is a lot of variation in the way we approach and a lot of discretion in the way we approach what is an aggravating circumstance and what is in fact a mitigating circumstance. So just sort of to delve a little deeper into it, I think there are various factors. For instance, the duration of the contravention. If it has been for a longer period of time, the CCI has in a lot of cases considered this to be an aggravating factor. On the other hand, the gravity and the nature of contravention. Now, while I speak, I also do have a realization that these are all terms that are very, very subjective. So as much as the aggravating and mitigating circumstances are not exhaustively laid down anywhere, but probably the way in which judgments have been passed in the last 13 years, in the last 15 years, that actually shows us the way in which the CCI has been operating. For instance, the CCI has also gone ahead to look at who is the affected party. So when they look at the markets, they also specifically look at who is the consumer, who is, let's say, the beneficiary. So, for instance, there's been a case in the insurance sector where the beneficiaries have been people who are below the poverty line. There, the CCI has taken a very strong view and said that, contraventions in this field or in this market have led to a lot of distress. And keeping that in view, a higher penalty must be imposed. Similarly, they've also been looking at the nature of the industry. They've also been looking at, for instance, if we look at the mitigating circumstances, COVID-19 was considered as a very important factor as a mitigating circumstance, and a lot of leeway was given to contravening enterprises in that duration. There are some more factors. For example, the cooperation that an enterprise, the way they cooperate with the investigative agency at the time in which there is an investigation going on, that has also been considered as a factor. There are various other factors that have been considered, but mostly these factors have also been implemented very subjectively. So having said that, we are not exactly falling in line with the way the rest of the world has operated till now. Of course, the 2024, the March guidelines that have come about are going to dramatically change the way we are going to look at it, specifically because now we're falling in line with the whole concept of global turnover, which was earlier only considered. The Supreme Court in a judgment had specifically spoken about relevant turnover only to be considered while imposition of penalties being done. But of course, now we're looking at how the guidelines are suggesting that because there are multi-sided markets that we are considering, because of the whole digital arena that is coming in, it is almost impossible, and like Shilpi had correctly pointed out, that it's almost impossible for us to only observe contraventions as horizontal and vertical. There is a lot of gray area that is coming in, and I think the adjudicators are also trying to cope up with that and keeping in view how the international jurisdictions or all other jurisdictions are operating. So of course, there are a lot of factors. I may not have been able to cover a lot of them exhaustively because there is a lot of subjectivity, there is a lot of discretion, and it's only, because it's time for us to just watch and learn as to how these penalty provisions are going to be implemented and how it changes the paradigm of the competition regime.
Thank you so much, Divya, for taking us through the most important section of this conversation, which was the penalty implication and how things are going on in India. With this, I would like to conclude this webinar and thank all the panelists for joining us today. I look forward for working with you all for an upcoming events, webinar, and things that is going around with GW Competition and Innovation Lab. Please like, subscribe on our LinkedIn page, visit our website for more updated events and publication that we keep on doing on a regular basis. Thank you so much, everyone, for joining.
Thank you, Lokesh. Thanks.
Thank you.
Thank Thank you. Thank you so much.
Thank you.